Hello everyone. In this particularly segment, we are going to discuss the Motor Vehicle Act from the section 167 to section 175. In these particularly series of section, we would be discussing about the claim tribunals. The claimant can get the claim, the compensation as a claim, and secondly the jurisdictions also, and the particularly the aspect for the procedures before the court. है ना? So these things we are just going to discuss in these certain sections. Now we'll be starting with section 167 of the Motor Vehicle Act. This particularly section more focused upon the options regarding the claims for the compensation in certain cases. The cases could be that where the death can be happen, or to any person there would be a bodily injury. Okay, so accident wale cases hai. These are the accident cases where you get the bodily harm or the bodily injury you survived. Okay, so now you can claim the compensation under the two important acts, that is the Motor Vehicle Act of 1988 and the second important act is Workmen Compensation Act of 1963. So in these both act you can claim the compensation. So now can we claim the dual compensation? Can we claim the dual compensation is the question arises here. So can we demand the compensation in both the acts? क्या हम दोनों एक्ट्स में कॉम्पनसेशन डिमांड कर सकते हैं? जो हमारा पहला एक्ट है जो बात करता है मोटर व्हीकल एक्ट 1988 एंड द सेकंड एक्ट इज द वर्क्समैन कॉम्पनसेशन एक्ट ऑफ 1923. सो कैन वी क्लेम कॉम्पनसेशन इन बोथ द एक्ट? नो. सो देयर इज अ कॉन्सेप्ट इन द law that we understood from our basics. Okay, that is no one get the benefit twice. Okay, so we cannot get the benefit twice if we are applying under both the act for the compensation. Okay, for a same particularly cause. Now likewise, if I'll give you an example that our lawyer will apply in both the case laws. Okay, in Motor Vehicle Act also and in the Workmen Compensation Act also. So if our lawyer will apply in both the cases, so the party will think that we can get the twice compensation. No, but where the compensation will be maximum awarded, we will claim that compensation. Our lawyer will claim that compensation basically. And under which act we have applied where we are not getting that much of compensation, that much of higher compensation as compared to other ones acts compensation that we are getting. So our lawyer will not टेक दैट कॉम्पनसेशन. अब पार्टी विल नॉट चूज बेसिकली द कॉम्पनसेशन. ठीक है, तो आपने दोनों में अप्लाई करा. जैसे कि अगर इफ आई ट्राई टू मेक यू बहुत सिंपल, आपने दोनों के लिए अप्लाई करा, लेकिन आपने दोनों एक्ट में अप्लाई करा कॉम्पनसेशन के लिए. जिस एक्ट में आपको कॉम्पनसेशन ज्यादा मिला आपने वो वाला बेसिकली कॉम्पनसेशन लिया, और जिस एक्ट में आपको कॉम्पनसेशन कम मिला वो वाला कॉम्पनसेशन यू हैवंट टेकन. ओके, so now the court has granted basically the compensation and you can claim compensation under one act only. Okay, so I hope you got this section 167. Now we will be moving further and be talking about the section 168 which talks about the award of the claim tribunals. Now how the award is granted in the claim tribunals, we have to see the procedure. Okay, so after giving a notice to the insurer means a person who had actually we would say insurance company. Let's suppose a person who is going to give the particularly payment or as a compensation, he would be an insurer, he will give, and court will send a notice to that person after giving a notice to the insurer, and the opportunities of being heard, OBH, will be given to both the parties, claimant as well as the person who is saying that I'm not going to give the compensation. Okay, so defendant and the claimant, they both are there, the both parties will be heard equally, and after that there will be an inquiry, holded. Okay, so after holding an inquiry for the claim, if the claim is legitimate, if the claim is the court thinks that the claim is so the claim is real, so on the basis of that the compensation will be determined, and when the compensation will be determined, the court will specify the amount and will say to a defendant, please pay the compensation to the claimant. And when the compensation is paid to the claimant, it could be we would say that that accident could be the compensation could be paid by the insurer, can be the owner, could be the driver of that particular vehicle who is driving, and due to his negligence particularly that accident has taken place. Now this was the first subsection of this particularly section 168. Now we'll be talking about the section 168 subclause 2. Now the claim tribunal shall arrange or deliver copies to both the parties of award. Now the claim tribunals will arrange parties to both the parties the copies of the award, and within a 15 period of a time from the date of award has been executed. Okay, so now the copies will be provided to both the parties within the 15 days of the period from which the award has been granted. Now the subsection 3 of the 168 says about the person who is required to pay the amount within the 30 days, who is required to pay any amount within 30 days of the date announcing the award by the claim tribunal. Now the person who has to pay the amount, he has to basically pay the amount within the 30 days as specified by the claim tribunal. Now the section 168 we have dealt in very depth, and now we'll be moving to section 169. Now 169 says about the procedure and the process of claim tribunal basically. So it actually follows the summary procedure. Summary procedure means that whole procedure will be concludatory. No, there will be no trial, nothing. Now the trial has been done at the basically the claim tribunals. Now there will be a summary procedure as be followed by the जो आपका होगा claim tribunal के द्वारा. ठीक है, as it think fix, because all the powers of the claim tribunals have the same like as in civil court. Okay, now here are the certain things that the procedure and the powers of the claim tribunal. So the first is the purpose of taking evidence on oath. Okay, the second is enforcing the attendance of witness. So any witness who is not coming to the court, so the court may say that come to the court, he can enforce, the court can enforce that particularly witness to produce before the court of law. The third is the compelling the discovery and production of documents and the material objects for other purposes. So some court can say that you have to bring this kind of documents, it's necessary. Okay, so court can compel to produce the important evidentiary documents. Okay, so now the fourth thing in this particularly section 169 is the section 195 of the Civil Procedure Code 1973, which talks about the administration. Okay, whole the thing will be summed up within the section 195 of the Civil Procedure Code as the administration follows there. Okay, now I hope you got it. The fourth thing that we'll be discussing in this, the purpose of enforcement of its award. Now the claim tribunals have the power of civil court, you know very well. Okay, so the execution degree, the execution of degree can be enforced by the civil court under the the claim tribunal. Okay, under the जो है आपका CPC 1908 का. ठीक है, तो उसके अंदर जो है कि कोर्ट यहाँ पे जो सिविल जो क्लेम ट्राइब्यूनल है कैन इन्फोर्स अ डिक्री, एक्सिक्यूशन ऑफ अ डिक्री ऑफ एन अवार्ड. ओके, सो in this particularly subsection 4 of the 169. Now we'll be moving to the section 173. Now the section 173 here will be dealing with the appeals. Okay, so appeal, any person aggrieved by an award of claims, a claim tribunal basically within the 90 days from date of the award prefer an appeal to high court. So now what happening here, because any person who is aggrieved, he is not getting award as he thinks with that I want this much of compensation, I got many heart injuries or many big loss I have suffered, so I want much compensation. But now the claim tribunal has given not much compensation to me, so the person is not satisfied by the award. Now he is approaching to the high court. Okay, so appeal can be filed under one section section 173 to the honorable high court and within the specified time of 90 days. Okay, from the date of which the claim tribunal has basically awarded that decree. Now in this particularly proviso, there is one proviso under section 173: no appeal by the person who is required to pay any amount in terms of such award shall be entertained by high court. So basically, unless there is one thing also, unless 25,000 or 50% of the amount awarded, whichever is less. Now there is one condition: if you want to file a appeal to the honorable high court, so what's the thing is necessary is that you must have you need to give some kind of fees to the court, that is of 25,000 or the 50% of the uh, award that you have get through the claim tribunal. Okay, so 50% of that award you can submit. Okay, let's suppose you have claimed around 1 lakh rupees of uh, compensation through the claim tribunal, and now you are thinking that I have get very less. Okay, I need to get around 4 lakhs or 5 lakhs. You have only get 1 lakh. Now what you can do is, if you want to file appeal to the honorable high court, so you can submit 25,000. Okay, or half of the 1 lakh, that is 50,000. You have to submit 50,000, or unless, or you can submit 25,000, so whichever is less. So supposingly only that 25,000 only you have to pay. Okay, because that is only the less amount. Okay, why to pay the 50,000? So this is something which we deal in the section 173. I hope you got it. Now moving further, we'll be talking about section 174. Okay, before going to section 174, there is also one proviso and subsection. Okay, so the proviso is that high court may entertain the appeal after the 90 days. Okay, expiry of the 90 days, the high court may basically entertain that particularly appeal. But there is an exception. Okay, and there is an exception is that if you have provided that it is the any kind of sufficient cause you have given to the high court, honorable high court, under the section 5 of Indian Limitation Act, so only on the basis of that high court can entertain your appeal. Rather, it may dismiss your appeal. So the proviso talks about that if 90 days has been expired, or you weren't able to file the appeal before the honorable high court, so you have to provide the sufficient cause that you may suffer from any injury, or you were not at that time at that place, you were somewhere else. So any kind of the thing, any kind of sufficient cause you have need to prove before, need to tell before the court of law. Now the subsection 2 here talks about the no appeal shall lie against any award of claim tribunals if the amount is less than 1 lakh. This is very important. If the amount is less than 1 lakh rupees, so you cannot actually file an appeal before the honorable high court. Okay, the claim tribunal has an awarded 80,000 rupees, let's suppose. Now you are saying that you have get less than the amount that you which you need to be get. Okay, so compensation is less 80,000. So now you don't have any option to go somewhere. You have to just take that amount only. Okay, 80,000. You won't able to file an appeal before the court of law to file before the high court. Okay, so if you want to go to the high court, that amount should be, if you want to file an appeal before the high court, so the amount should be more than 1 lakh rupees. This is the essential condition if you want to file an appeal. Okay, now we'll be dealing with section 174. So section 174 says about the recovery of money from insurer as area of land revenue. Okay, so claim tribunal may issue a certificate for amount to the collector, and the collector will recover as the area of land revenue. Now claim tribunal has certified, has actually issued an certificate to the collector that this amount has to be this amount has to be taken from the insurer. Now the collector will take that amount as he does for the collecting the area of land revenues. Okay, and what's the procedure for the collection of the areas of land revenues? That from legal actions only. Okay, the government will take the basically the collector will take the legal action. On the basis of that, he has to collect the particularly that compensation, and will be given to the claim tribunal. नाउ इफ आई विल बी गिविंग यू सम मोर एग्जांपल, जैसे कि कलेक्टर ऐसे वसूली करेगा जैसे एक एरियर ऑफ लैंड का होता है. ठीक है, एक एरियर ऑफ लैंड रेवेन्यू का होता है बेसिकली. अब जैसे एरियर ऑफ लैंड रेवेन्यू क्या आएगी, दैट्स द प्रॉपर्टीज बेसिकली द मनी द टैक्स ऑफ द प्रॉपर्टी. ओके, लेट्स सपोज if somebody is not giving the tax of the property from more than 10 years, now the what the particularly administration will do, the administration forcibly, okay, can take that tax from that particularly man, okay, which is who is not giving basically. Okay, or which may impose the penalties. There could be the second option. Okay, third, there could be that attachment of the property could be done. So all the options are available for the basically administration, for the government. So on the on the part of collector, he has to recover the money from that insurer who is not giving, or is giving basically, but the court will issue a direction to the collector that you please collect that particular compensation from the insurer. So insurer जो है कि उसको क्या है देना पड़ेगा collector को money, and that collector will submit the money before the claim tribunal, and then the claim tribunal will give that money to the particular who is the one who is suffering. Okay, so claimant को वो देगा, है ना. तो this is something which we have discussed in section 174. Now we'll be moving further and we'll be talking about section 175, which says about the bar on the jurisdiction of civil court. Can you apply any kind of अगर मामला जो है क्लेम ट्राइब्यूनल का है, तो क्या वो मामला सिविल कोर्ट की एडजुडिशिएशन में आता है? नहीं आता है. इट डजंट कम्स. ओके, and that there will be no injunction can be given by the civil court basically. So no, that claim tribunal basically has all the powers of civil court, which we need to understand. Okay, because the claim tribunal have the powers of the civil court, so why to approach the civil court then? Because he has all that particular authority, that particular institution has all the power of the civil courts, so that bars the jurisdiction of civil court. So there will be no such kind of case that can be dealt in the civil court. That can only be appeal before the high court. If you want, if you have any problem, if you are not getting as much of the compensation you need, you think that you must need, so you are not getting it, so you can go and appeal before the high court, है ना. So this is something which we have discussed under 175 section 175 that bars on the jurisdiction of civil court. सो सिविल कोर्ट के जुरिस्डिक्शन पे वो पूरी तरीके से बार लगा देता है. जो क्लेम ट्राइब्यूनल है बेसिकली वहीं पे जो है कि आपका जो डिसीजन है, डिक्री है, वो रहेगी, उसका ही माना जाएगा. एंड इफ यू आर नॉट सेटिस्फाइड विद दैट डिक्री, देन ओनली यू कैन अपील टू द ऑनरेबल हाई कोर्ट. दैट वी हैव ऑलरेडी डील्ड इन अपील ऑफ द सेक्शन 173 ऑफ द मोटर व्हीकल एक्ट. Now the last section is section 176. Now the section 176 basically talks about the state government may make rules for the purpose of provision. Now here what happens that government had some freedom. Okay, government gets some liberty to make rules with respect to the motor vehicle act from the section 165 to 174, but not included section 175. Why it is not included? Because that comes section 175 has the power of court only. Okay, so it has the power of court, so not to interfere in the judicial provisions. That's why that particularly section is not included here. So thank you for watching this particularly video. I'll be bringing such more kind of information to you. If you like it, please share this video. Thank you very much. We'll be meeting in the next very soon.